Good morning, hello, and welcome. Whether you are a student curious about privacy law or a professional navigating data protection in your field, or simply someone who wants to understand GDPR in a clear and simple way, this video is for you. In today's digital world, data is power and privacy is a right. That's where the General Data Protection Regulation or GDPR comes in. But understanding GDPR doesn't have to be complicated, and that's exactly what I aim to do in this video. Together, we'll walk through the origins and evolution of GDPR, uncover its scope and applicability, and explore its core principles like lawfulness, fairness, transparency, and purpose limitation. We will then dig into the legal basis for processing data and how organizations must earn the right to use personal information. You'll also learn about the 8 powerful rights granted to the data subject, from accessing their data to the right to be forgotten, and the obligations organizations must fulfill to stay compliant. I will also try to break down how enforcement works, what the penalties look like, and what this means for different industries like the tech, healthcare, education, and finance. But that's not all. We'll also zoom out and examine how GDPR fits into the larger world of data governance, how it has influenced global privacy laws, and the technological tools organizations use to stay compliant. We'll explore the ongoing debate of innovation versus regulation, look at the challenges and criticism GDPR faces today, and close with thoughts on the future of GDPR and data protection in an increasingly connected world. My goal in this video is simple: to make GDPR understandable, relatable, and relevant. Whether you're just starting out or you have been in the privacy and compliance space for years, we will go through as many aspects as possible so that the understanding is clearer and any fog on this subject can be taken off. So grab a cup of coffee, get comfortable, and let's explore GDPR simplified and demystified. Do not forget to like, share, and subscribe only if this has helped you in any form and shape. Leave a comment if you would like to explore other compliance tools like DORA, DPDP Act, NIST, AI regulations in future video. Well, do note some of them have already been covered in my earlier videos. Some are on the way. So keep a close watch on the channel. This is your host, Savit Vittal Salian. Namaskaram. And thanks for watching. So let's dive in. The General Data Protection Regulation or GDPR is a landmark legal framework enacted by the European Union to safeguard the personal data and privacy of its citizens. Effective from May 25, 2018, GDPR has had a profound impact on the data protection landscape worldwide. It replaces the Data Protection Directive known as 95/46/EC and aims to harmonize data privacy laws across Europe, strengthens individual rights, and reshapes how organizations across the region and globally approach data privacy. Given the digital age's increasing reliance on data, GDPR is both timely and transformative. This video dwells into the origins, core principles, scope, organizations, obligations, individual rights, enforcement mechanism, sectoral implication, global influence, and emerging challenges associated with GDPR. In simple terms, in today's digital world, companies and organizations collect a lot of personal data about people, like their name, phone numbers, emails, locations, and even online behaviors. But how do we make sure that this information is used responsibly and kept safe? That's where GDPR comes in. GDPR is a law created by the European Union to protect its people's personal data and their privacy. It came into effect on 25th May 2018 and it applies not only to the companies in Europe but also to any businesses around the world that handles the data of the people living in EU. The main idea of GDPR is to give people more control over their personal data, like knowing what data is being collected, why it has been collected, and how it's been used. It also ensures that companies handle data carefully and securely. Under GDPR, people have rights like the right to know what data is collected, the right to ask for corrections if there are gaps identified, the right to have their data deleted if they wish to, the right to say no to certain use of their data. Companies that don't follow the rules can face big fines. In short, GDPR helps create trust among people and the organization that uses their data, thus making sure everyone's personal information is treated with respect and care. The roots of GDPR can be traced back to the 1995 EU Data Protection Directive, which was among the earliest regulatory efforts to address data protection in the digital age. However, the directive's implementation varied across EU member states, leading to fragmented data protection laws. With the explosive growth in data volume, new technologies, and cross border data flows, there was a need for a unified regulation. Simply put, before GDPR came into existence, the rule for data protection in Europe were based on an old law called the Data Protection Directive, was created in 1995. Back then, the internet was still new and people didn't use smartphones, social media, or cloud storage the way we do today. So while the law was good start, it wasn't strong enough for the modern digital world. As technology advanced, people started sharing more and more personal data online, on websites, on apps, shopping platforms, and social media. At the same time, cybercrime, data leaks, and misuse of personal data became more common. This raised serious concerns about privacy and how people's personal information were being used without their clear knowledge or consent. The European Union realized that old rules need a big upgrade. So, in 2012, the EU began working on a new and stronger data protection law. After 4 years of discussion and planning, the GDPR was officially adopted in 2016 and it became enforceable on May 25th, 2018. GDPR replaced the old directive and created one clear set of rules for all EU countries. It also extended its reach beyond Europe, meaning that any company in the world that collects or uses data from people in the EU must follow GDPR. So, GDPR was born out of the need to keep up with new technology, stop misuse of personal data, give people more control over their own information, make sure companies act responsibly and transparently. It's one of the most important privacy laws in the world today, influencing how data is handled, not just in Europe but around the globe. The European Commission began drafting GDPR in 2012, aiming to update and strengthen the EU's data protection framework. After intense negotiations among the European Parliament, their councils, and commissions, the final version of GDPR was adopted in April 14th, 2016 and enforced on May 25th, 2018. That's the legislative journey of GDPR. Now, if you look at how it flowed over the years, 2009 to 2011, that's where the realization of the need kicked in. As technology grew, people started sharing more personal information online. At the same time, problems like data breaches, online tracking, and privacy violations also increased. The EU realized that the old laws from 1995 was outdated and couldn't protect people in the modern digital world. Then in 2012 January, the first proposal was put in place. In January 2012, the European Commission, which helps makes law in the EU, proposed a new data protection law, the GDPR. The goal was to strengthen privacy rights and create a single law for all EU countries instead of having different rules in each one. From 2012 to 2015, that's where the discussions and the negotiations were triggered. For the next few years, three main EU institutions worked together: the European Commission, the European Parliament, the Council of the European Union. These groups discussed and negotiated every part of the proposed law. This included how personal data should be handled, what rights people should have, and how businesses should be held accountable. So that's 2012 to 2015. Then, in April of 2016, after years of debate and adjustments, the final version of GDPR was officially approved. This meant all EU countries had to accept and follow the new rules. 2016 and 2018, also known as grace period for preparation. In this, even though GDPR was passed in 2016, it didn't start right away. The EU gave organizations 2 years to get ready, to review their data practice, update their privacy policies, and build better security system. Then on May 25th, 2018, GDPR came into force across all EU countries. From this date, organizations had to fully comply with the new rules or they could face large fines and penalties. In simple language, creating GDPR wasn't something that happened overnight. It took several years of planning, discussion, and agreement among many European organizations. Hope this helps you all to get a context. In summary, GDPR was proposed in 2012, approved in 2016, became enforceable in 2018. It took 6 years from proposal to enforcement, showing how seriously the EU took the task of protecting people's privacy in a connected world. From a territorial scope perspective, GDPR applies to organizations operating within EU, and from a non-EU organization perspective, if they are offering goods or services to EU residents or are monitoring their behavior, the GDPR scopes applies. This extra territorial scope is one of GDPR's most significant attributes, ensuring that global companies must comply if they are processing EU citizens' data. In simple language, one of the most powerful part of GDPR is its territorial scope, which means where and to whom the law applies. Most laws apply within the country or region that created them. But in this case, GDPR is different. It doesn't just apply to companies in the European Union, it also applies to many businesses outside the EU. Let's look at how it works. From a checklist perspective, we can determine if GDPR applies to your organization or activities. Do note, this checklist can be used by organizations to review their position, their current standing with respect to GDPR. Or if you are a risk manager, you can take this as a checklist to review it when you are doing your analysis, risk analysis. Or if you are an auditor, you can take this as a reference. Do note, this checklist can be used by the management or anyone interested in GDPR. Especially around compliances. Are you compliant to GDPR? If that conversation comes in, this checklist might just help you in some way. Of course, you can build on it. You can look at the full list of checklists from the GDPR website. And there are many references and additional information available on the net. I've taken up the top ones that gives you a direction. So starting off with, first thing is your business located in EU? That is, if a company is based in any EU country, it collects or uses personal data like names, email, or online activity, GDPR definitely applies to them. Example, a French online store collects customer data, means GDPR is applicable. From a checklist perspective, you can ask, is your organization based in EU? Second, is your main office located in EU country? Or do you have a branch office or employees in EU? Do you process the personal data of EU citizens, residents from within EU? If yes to any of these questions, GDPR applies. So you might be an organization based out of EU, all your offices are in EU, and so on. That is, you are not touching from any physical perspective. But you might have an employee based in EU or a citizen of EU working for you. Then guess what? GDPR would be applicable. Second, If your business is outside EU but deals with people in EU, even if a company is located outside Europe, GDPR still applies if they offer goods or services to people in EU, even if it is free, by the way. Yes, if you're providing free services, this GDPR still applies because you are providing services to a EU citizen. Whether you're monitoring the behavior of the people in EU, like tracking what they do online, GDPR is applicable. Example, a US based fitness app, supposing, lets people in Germany sign up and track their workout, GDPR applies in such cases. An Indian company advertises product to people in Italy. In this case, GDPR is applicable. So, from a checklist perspective, the first question you should check or ask is your organization based outside the EU but dealing with EU individuals? Do you offer goods or services to people in the EU? Do you allow EU customers to buy or use your product and services? Or do you offer your website in EU language or currency? Do you deliver or ship product to EU countries? If answer to any one, if all, surely, but even if it is one, GDPR applies to you. Now, if the question is, do you monitor the behavior of people in EU, or do you use web cookies or tracking tools on users from EU, or do you analyze user behavior from the EU for marketing or profiling, or do you track locations, online activities, or preferences of EU users? GDPR is applicable for you and your business. When I say you, it's your business. Yes. Now, question comes in, when GDPR does not apply? Well, the question to be asked in this case is, are you not targeting EU individuals at all? Or do you operate only outside EU? Is your website content only available to non-EU languages, in non-EU languages? Or do you block access or clearly state no service to EU users? If all or any one of them is a yes, GDPR is likely does not apply. Likely. Just be very, very conscious. There might be a caveat in your yes. To be sure, go 2 to 5 steps deeper in your queries. Just to be sure that you are sure that GDPR is not applicable. I've found out many places where to escape GDPR, the companies might naively or intentionally declare something which might not necessarily be true. It's not false, but maybe it's partial information. Hence, you have to be very conscious when you're dealing with this item, the fourth item on the screen. So, in summary, if a business does not offer goods or services to EU residents, doesn't monitor them, GDPR doesn't apply, even if the business is global. Example, a small bakery in Canada that only sells locally doesn't collect data from EU customers, GDPR doesn't apply. Well, why this matters? This wide reach means that business all around the world must be careful about how they handle personal data if they have EU customers or users. It also shows that EU takes data privacy very seriously and wants to ensure it is able to protect the people no matter where the company is located. Let's look at the material scope perspective. GDPR applies to the processing of personal data, defined as any information relating to an identifiable person, also known as data subject. This includes name, identification number, location data, and online identifier. In simple language, it means the material scope of GDPR means what type of data and activities the law covers. In simple words, GDPR applies to any activity that involves collecting, storing, using, or sharing personal data of people living in EU. What does the GDPR cover? When you say personal data, GDPR protects personal data, which means any information that can identify a person. Example, name, email address, phone numbers, home address, IP address, photos, bank details, online behaviors like browsing history. Basically, if the information can point to a specific person, it's personal data, and hence GDPR applies. From a processing activity perspective, GDPR applies to almost any action done with the personal data, such as collecting, example, online forms, or storing, example, in a database, or using it, example, for marketing purpose, sharing, example, with third parties, or deleting it. If an organization does anything with the personal data, it's called as processing, and that activity is covered by GDPR. Now, what GDPR does not cover? Well, there are few things GDPR does not apply to, such as personal or household use. That is, if you are just storing contacts or photos on your phone for personal use, GDPR does not apply. Example, saving your friend's birthday in your phone. No GDPR required. From a law enforcement and national security perspective, activities done by police or government of for law enforcement or national security usually follow different data protection rules under a separate EU directive. In short, GDPR applies to any organization or persons that processes personal data of people in EU unless it is for purely personal use or law enforcement. Now let's look at a few of the checklist. Maybe that will help you to understand it better. Of course, it can be used by the risk manager for doing the risk analysis. Your controls team can look at what controls need to be implemented on this checklist. Auditors can take this as a base reference when you are doing an audit on GDPR aspects for the organization. Organization, the management can look at these and try to gauge where they stand in the GDPR space. So, using this checklist to determine whether your data activities and type of data fall under the material scope of GDPR. Starting with, you should ask the question, are you processing personal data? Or are you collecting, using, storing, sharing, or deleting any information? Can the information identify a person directly or indirectly? Example, names, email, phones, number, IP address, location, photo, etc. If the answer is yes to all of them or any one of them, this is considered processing personal data under GDPR. The second question that you should ask is the data related to an identifiable individual? Can the data be linked to a specific person, example, a customer or an employee? Even if one piece of information doesn't identify someone, could it be combined with other information? If the answer is yes to any of these or all of these, GDPR applies to you or your organization. The next thing that you can ask yourself or the organization is the data processing done as part of a professional, business, or official activity? Or are you processing data in a business, government, or organization setting? Is the data used part of a service, sales, or operations? If the answer is yes, GDPR applies. On the other side, are you using data for purely personal or household use? Are you keeping the data only for private use, example, your personal contact list? Are you not sharing it or using it for business purpose? If the answer is yes, GDPR does not apply in this case, in these cases. Next is the data processed by law enforcement or national security agency? Is the data being used for crime prevention, investigation, or national defense? If the answer is yes, GDPR does not apply. But there's a separate rule under EU law enforcement directive which gets applied. But that's a case to case. Hope this checklist helps in getting closer to the understanding from a material scope perspective. Well, let's look at the core principles of GDPR. GDPR is built upon several foundational principles, namely lawfulness, fairness, and transparency. Organizations must process personal data lawfully and transparently, providing clear information to data subject about how their data is being used. In simple language, this means this is one of the core principles of GDPR. It means that when an organization collects and uses someone's personal data, it must do so in a way that is lawful, which means the organization must have a legal reason or called as legal basis to use your data. Some examples of lawful reasons are you gave your permission, called as consent, or they need the data to deliver a product or services you asked for. They have a legal duty to keep the data. They have a legitimate interest like fraud prevention, but it must not harm your rights. In short, they can't just collect or use your data without a valid reason under the law. The second aspect is being fair. The organization must use data in a fair way. That means they shouldn't trick you into giving your data. They shouldn't misuse your information. They must respect your rights and not use the data in a way that hurts you or surprises you. In short, they must treat your data and your privacy with respect. From a transparency perspective, the organization must be open and honest about what data they are collecting, why they are collecting it, how they'll use it, or who they will share with, or how long they plan to keep it. This information is usually shared in a privacy notice or privacy policy, which must be easy to understand. In short, you have the right to know what's happening with your data. From an example perspective, imagine signing up for a newsletter. From a lawful perspective, they ask for your consent before sending you the mail. From a fairness perspective, they don't use your email for anything other than the newsletter. From a transparency perspective, they clearly tell you in a privacy notice what they will do with your data. In summary, lawfulness, fairness, and transparency means you should always know what's happening with your data and it should be done in a legal and honest way. Let's try to look at it from a checklist perspective. Let's take lawlessness first. Ask yourself a question, or the organization can ask, are we processing data legally? Have you identified and documented a legal basis for the processing each type of personal data? The options include consent. Have you taken the consent? Is there a contractual necessity? Is there a legal obligation? Is there a vital interest associated with the data? Is there a public task? Is there a legitimate interest? Is your use of data limited to the legal purpose stated? Or have you ensured special category data like health or religion has additional protection? If yes to the above, your data processing is likely lawful. But do note, before you reach a conclusion of yes, are you sure the information that you have procured during this checklist are complete? Because one deviation can change the whole equation here. So, organizations doing this part of the activity need to be sensitive. If you're a risk manager, double check, triple check. If you're a auditor, you would need to be sure before you declare that this is in place. If you are a management guy, you need to be extremely sensitive that you are not on the wrong side of this. The next aspect is fairness. The question to be asked is, are you using the data in fair and respectful way? Are you avoiding deceptive or hidden use of data? Have you Are you only using data in a way that are reasonable and not harmful to the individual? Are individuals' expectations respected? Which is primarily no surprise on how the data was used. Or have you considered the potential impact on the individual when collecting or using their data? If the answer to all of these, all, not just one, all of these is yes, your data use is likely fair. But are you sure? That's where you need to go deeper before you come to a conclusion as it's an absolute yes. From a transparency perspective, the question that we should be asking is, are you being open and clear with people? Do you provide a clear, easy to understand privacy notice? Does your privacy notice include what personal data you are collecting, why you are collecting, how long you intend to keep it, who you share it with? Individual rights under GDPR are taken care of. How do you ensure that? How they can contact you for or your data protection officers? Do you tell individuals when you collect their data, even if it is in the form of another sources? Is your privacy policy easily accessible, example on your website or app? If the answer to all of these are yes, you are being transparent as required by GDPR. So the question here is, are you sure? So this has to be an careful activity, an important careful activity. If you slip on this and you come to a conclusion as yes, you are bound to get into trouble during any breach or an external review. Hence, better to be careful when you do this review. Hence, there is extra responsibility on the risk managers of the organization, the controls team who would be involved into defining the metrics on these if there are possible, and the audit team which would review it and come to a conclusion they are in compliance. Let's now look at purpose limitation. Data must be collected for specified, explicit, and legitimate purpose and not processed in ways incompatible with those purpose. What does it mean? In simple language, it means purpose limitation is when a company or organization collects your personal data, they must clearly tell you why they are collecting it. Only use it for that specific reason and not change the purpose later without a valid reason or your permission. So that's purpose limitation. Example, you sign up for an online course and give your names and email address. The purpose is to send you course material and updates. They cannot later use your email to send unrelated marketing messages unless you agree. What's not allowed? A company can't collect your data for one reason and then quietly start using it for something else. For example, a fitness app collects your health data to track workouts but then shares it with advertisers. That's not allowed unless you told them and got your consent. Why this matters? Purpose limitation protects your trust. It ensures your data is not misused, you are not taken by surprise, companies are clear and honest with you. In summary, purpose limitation means use my data only for the reason you told me, nothing more, nothing hidden. Let's look at the checklist. This checklist will help you make sure that personal data is only collected and used for specific, clear, and lawful purpose. The first question that you should be asking is, have you clearly defined the purpose? Have you clearly stated why you are collecting the data? Is the purpose specific, explicit, and legitimate? Is the purpose explained in your privacy policy or at the point of data collection? If the answer to this is yes, your purpose is clearly defined and compliant. If not, no worries, you can go and correct this and get in compliance. The next question is, are you only using your data for that purpose? Are you using the data only for the original reason you told the person? If you want to use the data for a new or a different purpose, have you checked if it's compatible with the original purpose? Have you informed the individual and collected fresh consent if needed? If the answer is yes, you are respecting the limits of the original purpose. If not, you would need to revisit. Are you avoiding purpose creep? That's your next question that you should be asking. Are you preventing teams or systems from using the data for unrelated tasks? Do you regularly review your data practice to make sure data isn't reused wrongly? Do employees understand the importance of not expanding usage without proper checks? If the answer to all of these is yes, you are protecting against misuse of personal data. If the answer is no, it is recommended to go back and fix the source of the issue. If the answer is I don't know, then you would need to reinvestigate and go deeper and do a check. Involve your risk managers and your auditors to do that part for you so that they can come out with a clear yes or a no. Till the time it is no, it means the action needs to be fixed. And you have to reach a situation where it is a clear yes. Ambiguity in this space can prove expensive at a later stages. Data minimization. Only data necessary for the stated purpose should be collected and processed. In simple terms, it means data minimization means that companies should only collect the personal data they really need, nothing more. They must ask, do we really need this information? Is this data necessary for what we are trying to do? Example, if you are signing up for a newsletter, they might need your email address, but they don't need your home address or passport number. Why this is important? First, it protects your privacy. It reduces the risk if there's a data breach. It shows respect for your personal information. What's not allowed? A company shouldn't collect extra data for just in case situation. They need it in future. Sometimes the company would collect it. That's not allowed. That's against GDPR. Example, an online store asks for your birthday even though it has nothing to do with your shipping your order. It's not necessary. So it may violate the data minimization rule. In summary, data minimization means only collect what you truly need and no more. Now, just to help it better, let's look at some checklist. This checklist helps ensure that your organization only collects and uses the personal data that is truly necessary for a specific purpose. The question that we should ask is, are you collecting only necessary data? Have you identified exactly what data is needed to achieve your stated purpose? Are you avoiding the collection of extra or optional personal data? Can you justify why each data field is required? If the answer is yes, your data collection is likely minimal and justified. The next question that you should be asking is, are you avoiding over collection? Are you avoiding just in case data collection? Are all your forms and system designed to collect only essential information? Do your staff know not to request more data than needed? If the answer is yes, you're protecting privacy and following the principle. The next question that you should ask is the data relevant and appropriate? Is the data directly related to your business or service activity? Are you avoiding data that is too detailed or sensitive if it is not required? Are you regularly reviewing data fields to remove unnecessary ones? If answer to all of these, not just one, all of this is yes, your data use is likely aligned with data minimization. The next thing that you should ask is, do you regularly review and adjust? Do you have regular data audits or review to check if all data collected is still needed? Do you update your forms, processes and policies to eliminate excess data fields? If the answer to all of this is yes, you are maintaining long-term compliance. Accuracy. Organizations must ensure personal data is accurate and kept up to date. In simple terms, it means the accuracy principle in GDPR means that any personal data a company or organization keeps about you must be correct, up to date, not misleading. If data is wrong or outdated, it should be fixed or deleted as soon as possible. Example, a company has your email address, but you change to a new one. If they are keeping using old emails, you might miss important updates. Under GDPR, they must update your information when you tell them. What's not allowed? Storing old, wrong, or incomplete data. Making decisions based on incorrect information is not allowed under GDPR. Example, if a credit agency has wrong debt record under your name, it could harm your credit score. That's a serious GDPR issue. Now, why does it matter? Keeping data accurate helps in preventing mistakes, protecting your reputation, making sure you get the right service or message. Under GDPR, you have the right to ask for corrections. If your personal data is wrong, this is called as right to recertification or rectification. In summary, accuracy means keep my data correct and up to date because mistakes can hurt me. Now let's understand through a checklist. This checklist helps ensure that the personal data your organization hold is correct, complete and up to date as required by GDPR. Let's start off with asking question. Are you collecting accurate data? Are you using reliable sources to collect this personal data? Do you verify the information at the time of collection? Do you give individuals a chance to review or confirm their data? If the answer to all of these are yes, you are starting with the correct data. Next question to ask is, are you keeping data up to date? Which means, which is actually, do you have a process to regularly check and update personal data? Do you provide users a way to edit or update their own information? Do you correct or remove outdated information when notified? If the answer to all of these is yes, you are maintaining the requirement from a data accuracy perspective. The next question to ask yourself and the organization is, do you have a correction process in place? Do you allow individuals to request correction, which is right to rectification? Do you respond to this request promptly and efficiently? Do you notify third parties if inaccurate data has already been shared? If the answer to all of these, all, not just one, is yes, your correction process supports GDPR rights. Next question to ask or investigate is, are you avoiding unnecessary or misleading data? Do you avoid recording unverified opinions as facts? Do you check whether collected data is still relevant and correct? Do you regularly clean your database to remove incorrect or duplicate data? If the answer to all of these are yes, you are reducing the risk of harm from inaccurate data. Storage limitations. Data should be kept only as long as necessary for processing purpose. What does it mean in simple terms? Storage limitation means that companies should not keep your personal data forever. They should only keep it for as long as they really need it and no longer. Once the data is no longer needed for the reason it was collected, it should be deleted or made anonymous. So it can't identify you anymore. Example, you apply for a job but don't get hired. The company may keep your name or resume for a short time in case of future openings. But keeping it for many years without your permission is not allowed. Now, what's not allowed? First, keeping customer data just in case for an unlimited time. Holding on to old files, emails, or database without a valid reason. Why does it matter? It reduces the risk of your data being stolen or misused. It matters because it protects your privacy over time. It matters because it ensures companies stay organized and responsible. You have the right to ask, how long will you keep my data? And if there is no good reason to keep it, you can ask them to delete it. In summary, storage limitations mean do not keep my data longer than needed. Clear it out when the job is done. Now let's look at the checklist. This checklist helps ensure your organization does not keep personal data longer than necessary and that you have a clear plan for data retention and disposal. You can start off with a question as to have you defined the retention period? Do you have a data retention policy that states how long each type of personal data will be kept? Are retention periods based on legal, contractual, or business needs? Are retention timelines communicated to individuals? Example, in your privacy policies. If the answer to all of this is yes, you have a clear limit on the data storage. The next question to ask yourself and the organization, if you are from a risk and audit world, is do you regularly review the data storage data? Do you have a regular data audits or reviews to identify old or unused personal data? Do you track when data was collected or last used? Do you remove or archive data that's no longer needed? If the answer is yes to all, you are actively managing data retention. The next question to probe is, do you securely delete data when no longer needed? Do you have a process to safely delete or anonymize personal data after its retention period has ended? Are deleted files unrecoverable and properly removed from backups or archives? Do you verify that data is fully erased across all systems? If yes, you are meeting the requirement to dispose of data properly. Now, the next question is, do you respect data subject rights related to storage? Do you honor requests for data deletion, which is right to erasure, when applicable? Do you stop processing or remove data if a person withdraws their consent or object to the use? If the answer is yes, you are respecting GDPR rights regarding data storage, integrity, and confidentiality. Appropriate security measures must be in place to protect data from unauthorized access, loss, or destruction. In simple terms, it means this principle is all about keeping your personal data safe and secure. It means that companies and organizations must protect your data from being lost, stolen, changed without permission, seen by the wrong people. Second aspect is using security measures like password, encryption, firewalls, access control, so only authorized people can see the data. An example here is a hospital stores your medical records. They must make sure only doctors and nurses who treat you can access them. The records are stored safely. Example, encrypted. They are not sent by mistake to someone else. Now, what's not allowed? Leaving personal data unprotected, sending private info over the internet without encryptions, giving access to employees who don't need it, Why does it matter? Well, it helps prevent data breaches, it protects you from identity theft or fraud, it builds trust between people and organizations. In summary, integrity and confidentiality means keeping my data safe, secure, and private. And don't let it be lost, changed, or seen by wrong people. Now, from a checklist perspective, let's look at it. This checklist helps ensure that personal data is kept secure, protected from unauthorized access or changes, and handles in a confidential manner. Let's look at the queries that you should ask yourself. Starting off, do you have a strong data security measure in place? Are you using passwords, firewalls, and encryption to protect your personal data? Do you use multi-factor authentications for systems that stores or access sensitive data? Are regular security patches and updates applied to your systems? If the answer is yes to all, your systems are protected against many security threats. The next question that you should be asking yourself and the organization is, do you control who can access your personal data? Do you limit access to personal data only to the staff who need it? Do you have a role based access control in place? Are access rights reviewed and updated regularly? Example, when someone changes role or leaves the company? If the answer to all of these are yes, you are reducing the risk of unauthorized access. The next query that you should have for yourself and the organization is, do you have a process to detect and respond to breaches? Do you have an up to date data breach response plan? Can you detect unauthorized access in the first place? Can you detect any loss or alteration to the data? Do you report breaches to the relevant authority within 72 hours or as required by the law? If the answer to all of these are yes, you are prepared to act quickly in case of a breach. The next is, do you protect data when it is shared or stored? Is your personal data encrypted or anonymized when stored or shared? Are secure channels used for transferring the data? Are cloud service provider and third party vendor assessed for their security compliances? If the answer to all of these, not just one, but all of these are yes, you are maintaining confidentiality even during data sharing. The next question that you should ask is, do you train your staff on data confidentiality? Do your employee receive regular training on data protection and security? Are there clear rules about how to handle sensitive data? Is there a confidentiality agreement in place for staffs and contractors? If the answer to all of these is yes, your team is equipped to handle data responsibly. Do note, the checklist that we have discussed till now have many components. The answers to all of these are required, not optional. It's not either these or there or one of these. No, all of it. Only then you are in compliance. Any misses on any one of the items makes you non-compliant. Hence, be aware when you are taking this checklist as a reference. And also do note, this is a top view on the checklist. A more granular checklist can be built, can be referenced from the GDPR full body of work. You can define and design more granular checklist yourself for your organization, because every organization is unique. But the principles of GDPR need to be referenced always with your checklist. Accountability. Organizations must demonstrate compliance with these principles and take responsibility for data protection practices. In simple terms, it means accountability means that companies and organizations must not only follow the rules of GDPR, they must also be able to prove they are following them. It's like saying, don't just say you are doing the right thing with people's data. Show it. What companies must do to be accountable? Organizations must keep records of what personal data they collect and how they use it. They should be able to show they have legal reasons for processing data. They should have clear privacy policies. They should be able to perform risk checks when needed, also called as data protection impact assessment. They should train their staff on data protection. They should appoint a data protection officer if required. An example, a company collects customer data for online orders. To be accountable, they should keep a list of what data they collected, like names, email address, and so on. They should be able to explain why they are collecting it. They should show how they keep it secure. They should prove they deleted it when it's no longer needed. Now, why does this matter? Well, it helps ensure that companies take responsibility for protecting your data. It makes it easier for data protection authority to check for compliance. It helps to build trust between businesses and customers. In summary, accountability means if you collect people's data, take responsibility and be ready to prove you are protecting it. Now let's look at a checklist. This checklist helps ensure your organization is not only complying with GDPR rules but also able to demonstrate that compliance through records, action, and ongoing efforts. Let's start off. The first question that you should ask is, do you have a clear documentation of GDPR compliances? Do you maintain a record of processing activities? Have you documented your legal basis for each data processing activity? Are data protection policies and procedures written and accessible? If the answer to all of these are yes, you are on the right track with documentation and transparency. The next question that one should ask is, do you have a data protection officer if required? Have you assessed whether a DPO is legally required for your organization? If appointed, does the DPO have a clear responsibilities and independence? Is the DPO contact information made available to both staff and data subjects? If the answer to all of these are yes, you are meeting the DPO's requirements effectively. The next question that you should ask is, do you conduct risk assessment and DPIAs? That is, do you conduct data protection impact assessment, which is DPIAs, for high risk processing? Do you assess risk to data subjects, rights, and freedom before launching new projects? Are data protection impact assessment outcome documented and addressed? If the answer to all of this is yes, you are proactively identifying and managing data risk. The next is, do you provide training and awareness? Which primarily is, do staff receive regular GDPR and data protection training? Are employees aware of their roles and responsibilities under GDPR? Is there a culture of privacy awareness and accountability within your organization? If the answer to all of this is yes, you are fostering informed and responsible data practice. The next question to ask is, do you monitor and review compliance? Do you carry out regular audits or internal review of data protection practices? Are third party processes also monitored for compliances? Do remember, this is not you, this is your third party or the organization which is supporting you to do your business. Do you keep records of compliance checks and any corrective action taken? If the answer is yes to all, you are maintaining active and ongoing accountability. The next question to ask yourself is, do you handle data subjects right properly? Or do you have clear processes to handle? Do you have right to access and right to rectification? You have the right to erase and rights to object. Do you respond to data subjects requests within 1 month? If the answer to all of this is yes, your accountability includes respecting individual rights. Let's look at the core principle in summary. The first principle is lawfulness, fairness, and transparency. Means data must be used legally, honestly, and openly. Real world example, informing users clearly when you are collecting their email address and how you use it. What organization must do? Identify a valid legal basis, be fair, don't mislead a user, provide clear privacy notices and consent options. The second principle is purpose limitation. Means use data only for specific reason it was collected. Example is using customer data to deliver a product, not for unrelated marketing without consent. What the organization must do? They must clearly define the purpose, avoid using data for new purpose without consent, update privacy notice if purpose has changed. Next one is data minimization. It means only collect what is necessary, nothing more. In real world example, asking only for names and email when someone signs up for newsletter, not their home address. From an organization action perspective, they should limit the data collection to what is essential, remove optional or excessive data fields. The next principle is accuracy. It's about keeping personal data correct and up to date. The real world example in this case is fixing a misspelled customer name or updating a changed phone number. What the organization must do in this case? Allow users to update correct data, regularly check and clean data for errors. The next principle is storage limitation, which means don't keep data longer than needed. In real world example is deleting job applications record after 6 months if they weren't been hired. From an organization perspective, they need to define retention period, securely delete or anonymize expired data. The next principle is integrity and confidentiality. It means keeping data safe from loss, leaks, or misuse. Real world example is encrypting customer data and limiting access to authorized staff only. From an organization perspective, the expectation is to implement encryption, access control, and breach response. The expectation is also to train staff on data security and confidentiality. The next principle is accountability. Means you must be able to show that you are complying with all GDPR principles. Real world example is keeping records of how and why you process data, showing proof of compliance during an audit. What the organization must be doing? They should maintain documentation, train staff, appoint a DPO if needed, regularly review and improve privacy practices. With this, we have come to end of part 1. In part 1, we covered the introduction, origins, and evolution of GDPR. We looked at the scope and applicability. We looked at the core principles of GDPR. We also looked at series of checklists. Hope those checklists helps you in your planning, your strategy, your approach towards managing GDPR in your space. Do comment if you think there are points that you would like me to go deeper. I might try to incorporate it in future videos. Thank you very much for the time that you have invested in this. This is your host, Savit Vittal Salian. See you in part 2. Namaskar.